चव्हाण सर. चव्हाण सर.
येस सर.
देशमुख साहेब आलेत का ह्याच्यामध्ये?
हो येणार आहेत. देवांगनी लॉग इन करून ठेवलंय.
अच्छा. नाही
एक 5 मिनिट आधी सर लॉग इन करणार आहेत.
अच्छा. मग पार्टिसिपेंट मध्ये अजून दिसत नाही.
सांगू का सरांना लॉग इन करायला?
हो सांगा ना, चालू करायला.
चालेल
लॉग इन
चालेल.
करा सांगा. आणि राजश्री तयार आहे ना?
येस सर.
हा ओके. Good afternoon to all. We are ready to start meeting. Just a minute. Good afternoon, sir.
Good afternoon.
Rajeshri, you start meeting.
Good afternoon all. I hope you all are doing fine and are safe during the pandemic. Lockdown is just a pause and not a full stop. So why not use this time to enhance legal knowledge? With the aim to utilize this time, MP Law College has organized a 15-day on law CET preparation. Today is the 7th day of our webinar. Previously, we have dealt with legal magazines, important landmark Supreme Court judgments, family law, law of torts, and legal aptitude and legal reasoning. Today, we have a very special and expertise personality, Senior Advocate Rajendra Deshmukh sir. Sir need no introduction, but as considering you all are new to the field, I take privilege to introduce the ocean of legal profession itself, that is Advocate Rajendra Deshmukh sir. Sir has completed Bachelor of Arts from University of Mumbai in 1984. and completed his LLB from the then Marathwada University, Aurangabad in 1987. Not only having exceptional academic career with a vast expertise lies within, Sir was a bright student of MP Law College, Aurangabad. Sir was a member of a team which had won runner-up trophy at national level moot court competition for the first time in the history of the then Marathwada University. Here, I would like to say that it's just the beginning of a star who is sparkling in the legal profession. This journey stay continued by representing MP Law College in various national moot court competitions. Not only this, but Sir has also represented MP Law College in various debate competitions and took part in extracurricular activities as well. After completing graduation in 1987, he got enrolled as an advocate at Bar Council of Maharashtra and Goa in 1988 and become life member of Advocate Association of Bombay High Court bench at Aurangabad and Aurangabad district. In this sparkling journey of 32 years in advocacy, Sir has worked as assistant government pleader, additional public prosecutor, panel advocate of Aurangabad Municipal Corporation and Municipal Corporation Dhule. Sir has proved that hard work is key to success and determination is the encouraging power booster to the success. By proving this, Sir is also appointed to represent High Court Registry and as a part of panel of lawyer who represent His Excellence Honorable Governor of Maharashtra. Having more than 130 reported judgments, Sir was also elected as a joint secretary and senior vice president at Advocate Association at Bombay High Court bench at Aurangabad. Sir is infamous for practicing in civil, criminal, constitutional, and service matters. Sir is also life member and trustee of Manikchand Pahade Law College, Aurangabad. The best example how Sir Advocate Rajendra Deshmukh Sir is the best example of how to be limitless. Sir was designated as senior advocate by Honorable High Court of Bombay in February 2020.
आपलं म्यूट आहे नका अनम्यूट आहे ना तिचा आवाज गेला आपलं अनम्यूट आहे
Sorry for the interruption. I would like to continue. Sir was designated as senior advocate by Honorable High Court of Bombay in February 2020. We are very honored to have such an eminent personality as well as an abundant academician as a knowledge resource person. Now I request Advocate Rajendra Deshmukh Sir to enlighten our attendees. Over to you, sir.
Thanks, Rajeshri. A very good afternoon to all of you. And I am really happy that I am amongst you all for giving lecture today on this law of crimes. As you know, friends, that law of crimes means practically a combination of or a bundle of 3 acts. That is the Code of Criminal Procedure, the Indian Penal Code, and the Evidence Act. Now, all these 3 are vast subjects. Means you must be knowing as student of law. I take it that you will be entering this legal fraternity, which according to me is a fascinating thing to happen in your life, in personal life or maybe in professional life. But then these 3 Code of Criminal Procedure, Indian Penal Code, and Evidence Act, when they are considered together, then you can think of law of crimes. So they are also termed as criminal major acts. Now, friends, I'll be trying to give you a slight idea. It will be practically an attempt on my part to tell you something like tip of the iceberg, because these three are vast subjects. But then I will try my level best to tell you, because you are the new entrants, so you must know as to what exactly this this law of crimes is. Now, as far as this Code of Criminal Procedure is concerned, 1973, it tells you regarding the criminal procedure which is to be followed throughout our country, and particularly the criminal proceedings are being regulated by Criminal Procedure Code. Now, friends, there are various chapters, various sections in this Criminal Procedure Code, and the chapters everywhere. Because you are a new student now, I must tell you that whenever you are looking at or reading any act, you please see section 2 first, which talks about the definition part. Now, as far as definition means, you will understand the terminology. Whatever terms are there in that particular code or in that particular act, you will find section 2. It gives you the clear-cut idea as to how that particular term is defined. Now, this particular criminal procedure code, it will be practically a bundle of as many as 484 sections. Criminal procedure code has undergone various amendments. To be very frank with you, recently we had these amendments in the year 2018. You know that after this horrendous incident of gang rape, which occurred on 16th of December 2012 in Delhi, famous for it is known, a famous case of Nirbhaya, that a committee headed by Justice J.S. Verma was set up to make the recommendation on amending the various laws to provide the speedy justice and also the enhanced punishment of the offenders in cases of sexual assault of extreme nature. Now, please, I must tell you one thing, that Criminal Procedure Code, when you take into consideration, it talks about various things. The preliminary part you will get in chapter 1, that is, as I told you, the section 2 definition part. Thereafter, in the next chapter 2, it is in relation to constitution of criminal courts and the offenses. You know, everywhere you will find that we have hierarchy of courts. We have the court of first instance. The Judicial Magistrate first class is the court of first instance at the ground level. Now, as far as metros are concerned, we have in the state of Maharashtra, we have Metropolitan Magistrate at Mumbai. So therefore, the hierarchy of courts is like this, that it is Judicial Magistrate first class, then thereafter it is Sessions Court, then the High Court, and then of course the things, if at all they are taken to, then it is Supreme Court. Please mind it well that as far as this constitution of criminal courts and offenses are concerned, all these things are to be considered in the fact this local jurisdiction, territorial jurisdiction, in which case is to be tried in which court, because many times you will find that incident happens at a particular place. You must be reading in newspapers that sometime there is a dispute in between two police station authorities, because either of them, they will claim that no, this particular incident has not taken place within the territorial jurisdiction of that particular police station. So therefore, but even then, if suppose something goes wrong and the crime is registered, if it is not concerned with that police station, still there is a machinery which is there. That is a crime number by crime number like 0. It is registered, and then it is transferred to the police station which has the territorial jurisdiction over that particular offense. So please mind it well. As far as chapter number 3 of the Criminal Procedure Code, it tells you regarding the power of courts, because which courts are to try which offenses, jurisdiction of the case, jurisdiction of the courts. There are number of accused persons you will find that they are not adult persons. They have committed the offenses when they are minor, so they are to be treated as juvenile. You might have heard, you might have read that in Nirbhaya's case also we got one of the accused persons a juvenile. So therefore he was not subjected to prosecution. The trial which had taken place, then subsequently he was tried before the juvenile court, and recently we found that he was released. So therefore this chapter 3 power of courts is concerned. Then chapter 4 is powers of superior officers of police. Basically, Criminal Procedure Code, Indian Penal Code, and Evidence Act, you will find three things. There are courts, there are police officers who are to investigate the offenses, and then the best part is, you must know, friends, one thing very clear. Basically, this is a system which we have adopted for administration of justice. Now, administration of justice is practically, it's a chariot. Now, that chariot aim is for the litigants. The litigants must get justice, and therefore it is rightly called that the two wheels of the chariots are the judges and the lawyers. But then, unless and until these two wheels, they run smoothly, the chariot will not move. Ultimately, we have to see that the litigant who is approaching to the court of law, he has to get justice. It is always said, friends, you must listen to this very carefully, that this is a criminal law where a person who is committing some offense, of course, he is to be taken to task. He is to be punished. Because why punishment? So that it's a signal to the others. The others will get this signal that, see, if I have done this particular act, then I have to be punished in this way. That is what is to be achieved. But then it so happens that ultimately a person who is committing offense is, but then there are certain class of persons who are at the receiving end. But then they are to come to the courts of law. The injustice must be conveyed. Otherwise, the machinery will not move. And that's why Criminal Procedure Code, you will find various chapters, chapter 5, arrest of persons, because basically, friends, all the provisions in all those codes and act, that is this criminal major acts, you will find the origin is the Constitution of India. So highest regard for the individual liberty, because for the freedom, for the expression, and therefore, if someone is to be arrested, then that particular arrest, it is to be taken in what way, what manner, that is also described in Criminal Procedure Code. There is another chapter by name chapter 6, that is processes to compel appearance. See, somebody is an accused person, somebody is to be summoned, maybe in the capacity of accused, maybe in the capacity of witness, but then there is a procedure. You just can't, I must tell you, please take it in the lighter vein actually, but then we all are, we are subjected to various things. I always tell when I teach law in the law college, I always tell all my students of law that fortunately, because you are fortunate, you belong to such generation that you have live examples and demonstrations around you. And therefore, I can teach you, I can give you more demonstrations while considering all those provisions of this code and acts. But mind it well that when you are exposed to this situation, please read law, please see that all these provisions, when I'm telling you regarding all the chapters in the Criminal Procedure Code, just have a glance over it. Whenever you are studying any code or any act, please see that you go through the provisions. Chapter 6 is process to compel appearance, then there is warrant of arrest, then there is proclamation and attachment. This particular Criminal Procedure Code, it is in relation to a person who is committing an offense. You have to see that he is punished. But then for that, if suppose it's a cognizable offense, cognizable means a police personnel or their concerned investigating officer, he can arrest the person without warrant. Non-cognizable offense means a person, he cannot be arrested without warrant. So that's the distinction. Please take into consideration. And therefore, if suppose it's a warrant case, it's a summons case, all these things are to be seen. A person, if he is not available to the investigating agency, still, then it can be seen that a proclamation is made, his attachment of the property has to be taken place. But then, of course, this is to be done by following certain procedure. I may tell you, friends, you must be knowing that the various things we come across, rather, that there is a case of Daud, there is case of Malya, there are other cases where the Indian government is trying to get the property attached, Indian government is trying to get these persons deported back to India. Why? To face the prosecution. But then once they are there, then you have to follow the Criminal Procedure Code. We all know the famous Kasab case. Now everybody saw it on television, that Kasab killed so many people at at CST Mumbai, but then still it is not that this only because we could see that this person Kasab has committed this offense. Ultimately, he was put on trial. He was also given an assistance of a lawyer. So therefore, we believe in this system where the accused also has to be given fullest opportunity to defend him. You cannot just take him to task and you cannot tell him that, yes, Mr. you are guilty. The innocence of the accused person also has the highest regard till, of course, the trial takes place and he is proclaimed or he is held to be guilty by the concerned or competent court. Friends, I must tell you one more thing. It so happens that a person who is facing or subjected to trial, he may have so many defenses also. Those things also you may get. But then once the trial is to take place, what procedure is to be followed, that exactly you get it in the criminal procedure code. I was telling you one more thing. You must be reading so many things. You must be watching the dramas. You must be watching the movies. You must be finding so many things now in this Netflix, etc. But then mind it well, all those things when they are referred to in relation to our courtroom dramas, sometimes I as a student of law, I know that the things are exaggerated. It may not be the correct procedure which is being reflected over there. But then as a student of law, you must take care. You must be live to this thing that no, this is the procedure, because ultimately it's a drama. It's a movie which we are watching. Real life, real courts are different, friends. Please try to understand this. And therefore, if suppose the other chapters are concerned, there are security to be of keeping the peace and for good behavior. The famous section is section 107, where a person is asked to see that 107 action, that particular security for keeping the peace is taken. That usually happens because India is called as, the country when we are celebrating many things throughout the year. Please don't consider that now because we are in a pandemic situation, so therefore we have slowed down. Otherwise, India is known for its colorful life, for the celebrations which we make throughout the. But then when these celebrations are there, maybe Diwali, maybe Dashera, maybe Eid, maybe Christmas, all those times are testing times for the agencies who are maintaining law and order. And then, friends, it so happens that this type of security for keeping the peace in the area are being taken from the persons who are, of course, who have criminal antecedents. Now, what is this criminal antecedents means? They have been booked in some offenses in the past. So therefore, the care is being taken that they should not repeat the offenses. There are also this criminal procedure code. One of the other fascinating part is that you will get chapter 9, which deals with the order of maintenance of wives, children, and parents. Friends, I must tell you frankly, nowadays you must be knowing, you must be reading in the newspapers that there are many matrimonial disputes, there are many matrimonial cases flooded, the family courts are flooded. But then in such thing, you know that there are these persons who are at the receiving end, and normally the wife, the children, the parents, they can approach to the court of law and they can file an application for maintenance. And then in what way it should be asked for, it should be prayed for, whether once maintenance is granted, can it be altered subsequently, can that order be modified, can that order and then the most important thing is enforcement of order of maintenance. That is very important. Friends, I must tell you frankly one thing. India is a country where you will find there are so many laws, so many things are there, but unfortunately there is no proper training to the concerned. Maybe it's happening this way, that the law is there, it takes care of every possible thing, there is solution for everything in the law. But unfortunately, when there is no training, proper training rather, someone who is responsible or at the helm of the affairs, he may not be knowing. But then that has to be seen from this angle, that if you are a student of law, the only option for you is that please read and read. I still remember, I give this example time and again, that one of the most honorable judges from our High Court, because many of them, they come to our law college at Aurangabad, we felicitate them, then they give us lecture. But then one of the most Justice P.V. Hardas, who once upon a time, when he was called at the college, and then he was telling that this particular thing, the honorable judge was explaining the things, that lawyer's job or this law student's job is quite difficult. You have to be very honest. It's a hard work. But then one of the students, he stood up and he said, "Sir, can there be some shortcut for the hard work?" Everybody was taken aback that what can be the answer for this now. But the honorable justice was quite clear in his mind, and he said that yes, for hard work there is a shortcut, and that is more hard work. So that is how you have to work. You have to work and you have to read. And so therefore, friends, if suppose these chapters further, if suppose we see this, there are preventive action by the police when chapter 11 of the Criminal Procedure Code, police to prevent certain cognizable offenses, information of design to commit cognizable offenses. Then there is another chapter. The most fascinating part starts from section 154, that is chapter 12, because section 154, according to me, it's a starting point for investigation, because that you all know are of representatives from this generation. This generation, you are exposed to so many things, but then this is a button. This is particularly a starting point. Some information in relation to, there is a disclosure of a commission of an offense which is cognizable, and then section 154 comes into play, because under section 154, first information report is lodged to the concerned police station. The crime is registered, and thereafter the investigation starts. And thereafter you will find, friends, that during the course of the investigation, the accused are arrested. They are put up before the concerned magistrate. Any person so arrested, he is to be produced before the nearest magistrate within 24 hours. It so happens that the crime has taken place here at Aurangabad, but somebody is arrested maybe at a far off place. Then after his arrest, he has to be produced before the nearest magistrate. Tell the magistrate that, sir, we have arrested into him. If the arrest is made in relation to some other offense which has taken place at a far off place, so you have to take the permission. This is a transit period. Friends, there are so many things, fascinating things which happens when you read Criminal Procedure Code. Because 154, as I said, starting point, investigating, arrest of the persons. Then there are 161 statements which are recorded. 161, section 161 means during the course of the investigation, there are witnesses whose statements are recorded by the police. Someone may say that, sir, in front of me, this particular thing has happened. So he can claim to be an eyewitness to the incident. Someone may say that, sir, I have heard it. So it's a hearsay evidence, but still all those statements are recorded under section 164. Nowadays, you will find that there is a care is being taken by the investigating agency to see that further this statement, apart from this 161 statement, because 161 statements are not admissible in the courts of law when the trial takes place, because these are the statements before the police, in front of the police. So natural presumption is that you are in the custody. You have given this particular information. One doesn't know, maybe under duress, maybe under pressure, maybe under influence. But then that 161 statement also can be believed, can be relied upon by the courts. When that particular witness comes before the court, steps into the witness box, tells the same thing to the court, then he is cross-examined, he is not shaken, and then that statement can very well be relied upon. But nowadays, it so happens that many occasions we see that 161 statements do not help to the prosecution because the witnesses are turning hostile. So therefore, the care is being taken that statements under section 164 are recorded before the magistrate. Then it has its own sanctity. So therefore, friends, 164, etc., after completion of the investigation, there is section 173, that is the final report, submission of the charge sheet. Means after collection of evidence, if the prosecution wants to convey to the court that, sir, we have enough material with us to prosecute this, to put this particular accused person on trial for commission of these many offenses. But friends, don't forget one thing, that prior to 173, there is 169 also, where the police investigating agency, rather, it can convey to the court that, sir, we have investigated, but then we could not find anything against this particular accused. So therefore, this is our report. Please permit us to close the case. But then that is also not an empty formality. Because if such a report is filed before the court, as per the Supreme Court pronouncements, various judgments are there, it says initially in earlier era, it was so happening that a report goes to the court, court accepts it, and the case is closed. But then what about the informant? What about the complainant who has set the law in motion? He must know, wow, what happened, how the investigation has taken place, because there are cases and cases where you can find that the investigation is tainted. Investigation is in hand in gloves with the accused person. So what about the right of the informant or the complainant? Supreme Court recognized it, and Supreme Court said that, see, if such a report under Section 169 is submitted before the criminal court, it's the duty of the court to call, to issue a notice to that particular informant or complainant. He should come before the court. He is normally represented through lawyer, and then he also addresses to the court and tells whatever he wants to tell. He may dispute strongly. He may file his protest petition that, sir, please don't accept this report. And that is what is happening. So thereafter, again, court will either accept the report or court may not accept the report. Court may reject the report. Court will accept the protest of the informant, protest petition. So that is what it happens. Friends, but then when I told you regarding 173, it is the impression somehow that 173, once charge sheet is filed, means everything is over. No, friends. In the charge sheet, you will always find that the investigating officer seeks permission of the court that, sir, please, I reserve my right to file a supplementary charge sheet also, 173 subsection 8. Please also read that. 173.8 talks about this thing, that if suppose some information is subsequently is there to this particular investigating agency, he can investigate. He can still go on with the investigation. You know, you will find, you must have read about it, that so many times you find that the accused are not traceable, they are not arrested, they, in spite of the fact that they are not getting any pre-arrest protection orders from the competent courts, still they are not available for investigation. Means in the eyes of law, he is absconding. So in that case, criminal procedure court takes care of such a situation, that the charge sheet is filed against that particular applicant under section 299 of the criminal procedure code. Means a person is absconding, he is not available, but that doesn't mean that the charge sheet cannot be filed against him. The status of the person would be that you are absconding, but the charge sheet is filed. Now, whenever he will be available, he will be put to trial, he will be subjected to trial, and that's what normally happens. But then, friends, there is one more thing, that these particular criminal trials, because the subsequent chapter 13 is in relation to jurisdiction of the criminal courts in inquiries and trials. Normally, whenever the offense takes place, that particular crime is registered at a police station because it has territorial jurisdiction over some area where the offense has taken place. Something has been done. So therefore, naturally, the courts which are situated there, local courts having territorial jurisdiction over that area or the police station, would try that particular offense. So therefore, this jurisdiction of the case is very important. I must tell you that I had an occasion to argue a pre-arrest protection, that is anticipatory bail matter, before the High Court. The accused persons were from Hyderabad and the crime was registered at Aurangabad. And so therefore, the first query to me from the Honorable Judge was that, see, Mr., your persons are from Hyderabad. So even if suppose I grant you bail, my bail order can take care of you till the territorial jurisdiction of Maharashtra state. That is still boundary. What about thereafter? Because you are from Hyderabad. If suppose you are arrested there, how can you be held by this order? So then the situation was, the code says ultimately what is important is not the residence of the accused. What is to be seen is where the crime is registered. Crime is registered at Aurangabad. So naturally, the police personnel from Aurangabad will go to Hyderabad. They will, of course, intimate to their counterparts over there that they are there in relation to the investigation of this particular crime. And then with the permission, with the assistance, with the help of those police personnel at Hyderabad, they may arrest the person. So therefore, what is relevant is the registration of crime. What is not relevant is the residence of the accused persons. Please mind it well. Thereafter, we also see that there is also a chapter that is conditions requisite for initiation of proceeding, cognizance when taken, transfer of the application. But then the main chapter which I would like to tell you is this in relation to trial, because when the trial takes place after submission of the charges, these charges, that's why, friends, why this law of crimes is to be seen from all angles. Why this? When you have to study Criminal Procedure Code, number one. Number two, Indian Penal Code, and number three, Indian Evidence Act. Now, why Indian Penal Code is important? Because any person now subjected to trial, he will be facing the prosecution for committing the offenses under section so and so of the Indian Penal Code. Now, IPC means something, offenses against the body, offenses against the human body. So therefore, but then all these offenses in Schedule 1 of the Indian Penal Code, they are classified. It's a classification you get. How the classification is this way, that first thing is you have to see what punishment is provided for commission of this offense. If the punishment is on the lower side, then naturally you will find that this particular punishment, if suppose it is 3 months, 6 months, like that, then in that case you can say that the court of first instance, judicial magistrate first class, can try this offense, because classification tells you this only, that it's a punishment what is provided for. Number two, whether it is bailable or non-bailable. Number three, whether it is cognizable or non-cognizable. Number four, it is triable by whom, whether by the court of magistrate or by the court of sessions. There is one more column which again is there, but then classification you must also know, because you will find that many a times it so happens that the parties, they do get compromise the matter. You know, it may be out of court, in the court, sometimes it happens. But then in criminal courts, there is again a section 320 in the Criminal Procedure Code which talks about compounding of offense. Now, compounding takes place with the permission of the court, of course. But then there are certain offenses, it's the list of offenses which are given, that those can be compounded. Otherwise, it's not possible. But then now the law has settled like anything. Law has been crystallized time and again. And therefore, friends, you will find one more thing which I must tell you very frankly. Why law is crystallized time and again? Why we are getting all sort of judgments every day from Apex Court, from various high courts, and particularly Bombay High Court? It's only because of this, that law is something like, law is not static. It's a fascinating subject to study and to practice also. Law is open for interpretation. Law is not like mathematics. Mathematics, you will find 2 into 2, 4, 100 years back, today, and 100 years hereafter. But it's not applicable in law. Law changes according to the needs of the society. Law takes care of the public at large. And therefore, from my experience, I must tell you that I was dealing with the cases, because I have started practice maybe 32 years back. So there I was, I was required to deal with cases where there were cases, the husbands were, they were prosecuted for committing of offense, that he has ill-treated his wife, he has killed his wife, he has murdered somebody, something like that. But then nowadays, I am also getting cases where wife are killing husbands, wife are this thing. So therefore, the things are changed, the society is changing. That doesn't mean that anything can happen. Law takes care of every possible thing. But then for that purpose, you have to think about the trial part. Now, trial part is something fascinating again, because there you will find that the evidence is laid by the prosecution. Indian Penal Code tells, as I told you, classification. Then the evidence will be laid by the prosecution. The accused lawyer will have a chance to cross-examine the prosecution witnesses. The accused will also have a right to see that a defense witness is there in support of whatever theory he put forth. So therefore, it happens this way, because many times you will find, friends, that these cases are such where the defense of the accused person is of total denial. Because normally criminal law is this, that this particular case is being tried by the state. If suppose I have committed some offense, it will not be the case like complainant, that particular ABC versus so and so. It will be state against that particular accused, because ultimately the state is the custodian of law and order. So therefore, state versus so and so. Therefore, the public prosecutor, he is in charge of prosecution. Therefore, it takes also care of this thing. Normally, the defense is total denial. I don't know. Prove, Mr. Prosecution has to prove that this particular crime has taken place. You have committed this offense. That is what happens. But then there are certain exceptions also. When you talk about certain special acts, that is Prevention of Corruption Act, where there is a trap, and in that trap you find that that particular officer was taking bribe, then in that case the burden shifts on the accused. He must prove that why he was taking that particular money. So it's not the normal or usual case under criminal law, which we see that no, Mr. that you have prosecution has to know it. Sometimes it is different also. You will also find when the case proceeds in the trial court, charge is framed, the accused is asked whether you plead guilty or not. Many a times it so happens that if they are petty offenses, accused are pleading guilty, depositing fine and getting free. But then serious offenses, suppose 302 murder is there, 376 rape is there, 395 dacoity is there. All these are major offenses. 303 that you are a life convict but committing murder again. So these are serious offenses. And why any offense is serious? See, because the code provides, this Indian Penal Code, it provides punishment. 302 means murder. You have killed somebody, you have murdered somebody. And in that way, you will find that life is so precious. Ultimately, why this Indian Penal Code is there? Because it's something taking care of a life of a human being. You are not permitted, it's not permissible for you to take the life of a man, because life is very precious. You cannot give life to somebody once you kill him. Therefore, the law has highest regard for the life of the person. And therefore, naturally, the punishment is for 302, minimum punishment is life imprisonment, and the maximum punishment is capital punishment, that is death, that is hanging till death. So therefore, all these things, charge, plead guilty, he claims, then he says that, sir, no, I don't plead guilty. Then he claims to be tried. He discloses his defense. Then prosecution examines the witness. His lawyer cross-examines him. And thereafter, one more thing you must remember. All this particular leading of evidence, recording of evidence, it has to take place in the presence of the accused person. He must be there. Because after whole set of evidence, that is recording of evidence, is over, then the important section of 313 from Criminal Procedure Code, that the court asks the question to the accused person that, see, Mr. You have seen there are 10 witnesses prosecution has examined who have come and deposed against you. Now, please let us know why this fellow is telling against you. What do you want to say about it? Then he can have his own justification. Nowadays, you will find that the accused persons are filing even returns, 313 statement, written submission, what is their defense, what they want to say. And after considering this, it may so happen that the court may pronounce the judgment and order. Court will, of course, take into the consideration that there has to be an appreciation of evidence. Evidence consists of both documentary and oral. So therefore, friends, this trial before the magistrates, trial before the court of sessions, it takes place. There are trials before the summons case, warrant case before the magistrate. All these things are regulated by criminal procedure. But then again, one of the fascinating chapter, that is the added one rather, chapter 21A is plea bargaining. Now you'll find that this application of plea bargaining means something is being done before the court of law. That is an attempt to settle the matter. The plea of bargaining is normally not permissible in the criminal courts. You friends, you must understand one thing. We are never to bargain with the court. That is not permissible at all. But by way of this chapter 21A, it is being stated that this particular is for this reason, that to see that the dispute or that particular trial comes to an end. Friends, you must know one thing. This, I think the basic purpose behind this plea bargaining is this, that you know our system is flooded with work. System is under tremendous pressure of pendency of matters, pendency of various trials. So many under trials are languishing in jails. You must have heard, because of this today's pandemic situation, this COVID-19, the state government has directed, state government has come out with this. Then there was a high power committee which took decision that to see that social distancing is available, but then in jails are overcrowded. You will find that the capacity of the jail is 1,000, but the persons who are there lodged in the jail, they are more than 1,000, sometimes 2,000, sometimes 3,000. So how you will achieve this social distancing? So therefore, a scheme is floated that, see, whoever is applicable, this high power committee, it has given certain suggestions. If suppose someone is fulfilling that criteria, he can be released temporarily. So that is what is that. That is what. So I was telling you, law takes care of everything. It has solution for everything. Only thing is that you have to read and you have to study. Then also this thing that there are chapters of regarding evidence, how the evidence is to be recorded. Then thereafter, the most important section Criminal Procedure Code talks about is regarding the arrest and regarding also these provisions in relation to anticipatory bail. Section 438. Someone who comes to know that a crime is registered against him, he is named over there. So he is apprehending arrest. He is a reputed fellow. He is having his own name, fame in the society. If he is arrested, his image will be lowered down. Then he can very well go to the court of law, the court of first instance, that is the sessions court, and he can pray. Of course, you will find section 438, it talks about the concurrent jurisdiction. What do you mean by concurrent? Means you can file an application under section 438 for anticipatory bail before the court of sessions or before Honorable High Court also. But always it is being said and it is being conveyed through many judgments by the high courts, various high courts, and also by the apex court, that an applicant has to approach the court of first instance. It should be, so therefore normally it is seen that the applications are first made to the sessions court, and thereafter if suppose they are granted or rejected, then the things come to high court. But then 438, it talks about the reasonable apprehension in the mind of that particular person in relation to arrest, in relation to that particular crime where it is registered. So you must tell that it doesn't happen that there is no crime registered. There is no crime registered and still you are applying for bail. Or there are cases where sometimes it so happens that the offenses alleged against you, they are bailable. Now, bailable means what? When you go to the police, when you are called by the police, police cannot take you in custody. Police are to release you, of course, after completion of certain documentary formalities. But then if suppose you have, sometimes, some applicants come before the court and say that, sir, I have gone to the police, but then I have an apprehension that I might be put behind the bars, but then offenses are bailable. Then in that case, anticipatory bail request is not considered. It is said that if suppose the offenses are bailable, where is the question of this pre-arrest protection at all? So therefore, 438 takes care of that. 430, and every bail application, you will find, friends, every bail application, there is a famous magazine. You must have heard or you will be studying that. One of the eminent jurists from or eminent judge of the Supreme Court by name Justice Krishna Iyer from Kerala. He was one of the greatest judges of this country has ever produced. And Justice Krishna Iyer in his famous judgment has said that whether bail or jail, and bail should be a rule, jail should be an ethics. So therefore, this thing, please mind it well, that it is something like this concerning with the freedom of the person. A liberty is being taken off. And so therefore, courts have to see whether that particular thing, care is being taken or not. 438, 439 talks about post-arrest bail. Now, post-arrest means a person could not get, maybe that he is arrested before he could go to the courts of law and think of pre-arrest protection. But he is arrested. But then still, to apply for bail is a right given to the applicant accused. But to get the bail is not a right. That is the discretion of the court. The court has to exercise the discretion. Court has to say what exactly is the material which is being put forth before the courts. You will also find, friends, most important thing when you go through the different various provisions of this code and Indian Penal Code and of course the Evidence Act, because Evidence Act tells you regarding the admissibility of evidence, how the evidence has to be evaluated, how it is to be appreciated, which evidence is admissible, which evidence is not admissible. Take a simple case. If it's a public document, more than the public document is there, then it is definitely admissible. One of the most fascinating part of Evidence Act is section 32, that is dying declaration. Somebody on deathbed, he is making a statement in relation to cause of death, his cause of death, or the circumstances leading to this particular thing that he is to die. Then it is being said, or it is being stated, it is being accepted, it is being presumed that someone who is making a statement on deathbed, he may not say untrue things. And therefore, whatever he says in relation to the cause of death or the circumstances are to be considered as true things. And therefore, dying declaration has its own importance. But of course, it has to be evaluated before the court during trial. the sole dying declaration can also be the basis for conviction. Then it also tells us how the dying declaration is to be recorded, by whom, how it has to be done in the presence of the medical officer, how he is to certify that he is fit to say something, because there are so many things. Naturally, I was on this point to tell you that any person who is claiming bail and going before the court, criminal court, he cannot get or he cannot pray for blanket bail. He has to tell the court, he has to request the court that, sir, I am ready for cooperating with the investigating agency. Investigation, I will fully cooperate. I will not run away. I will be making myself available to the investigation. Please grant me bail, because if it's a case of pre-arrest protection, because these are the things which I can demonstrate that, no, I have no concern with this commission of the crime, and then my reputation, my name, fame, etc. But that also, even only because that you are a moneyed person, you have muscle power, that doesn't mean that you will get pre-arrest protection. You have to make out a prima facie case. You have to convince the judge that, sir, these are the parameters. And therefore, it is always said by all the courts that parameters for consideration while you consider regular bail and anticipatory bail are totally different. Anticipatory bail means something he is anticipating. He is anticipating his arrest. He wants pre-arrest protection, and therefore this is very important. But at the same time, he is to undertake to the court that, sir, please grant me this order and I undertake to cooperate. So therefore, bail orders are always conditional. Conditional means you have to attend the police station, you have to cooperate, you are not to tamper with the prosecution witnesses. Many times you will find, you must have read in the newspapers, that court directs that if you have passport, please surrender with the investigating agency. You are not supposed to leave India without the permission of the court. There are so many things by which court takes care. Somebody who wants to be released or who wants a this arrest protection order, court takes care that that person is available to the investigating agency. There is one more thing which you must also see. Why this criminal procedure code regulates everything? Because the basic thing is that the accused is entitled for a speedy trial, for a fair trial, and that is the most important thing to happen. Again, the origin goes to Constitution of India. Speedy trial is something that is why you will find that so many under trials are languishing in jail. It so happens that their cases are not being heard for years together. But then that is something different, problems with the system. System has its own infrastructure, and therefore courts are working very hard to face this situation. But then this particular speedy trial is a right of a person who is an accused and who is facing the trial. He has also a right of fair trial. These two things are very important. And so therefore, friends, when we talk about when the trial court, if suppose trial court acquits you, that doesn't mean that you are acquitted, you are scot-free. No, that acquittal can be challenged in appeal also. You will find section 378 that there the provisions of appeal, if suppose you are acquitted, in some cases the appeal directly lies to the High Court. But if you are convicted, of course, by the Sessions Court or by the Magistrate Court, if by the Magistrate Court you are convicted, you can go in appeal to the Sessions Court. If you are convicted by the Sessions Court, you can go in appeal before the High Court. There is also a provision in the Criminal Procedure Code, that is section 389, that talks about the suspension of the sentence, that is to enable that particular applicant accused who has been held guilty and who has been punished or who has been sentenced to suffer a sentence which is below than 3 years, means 3 years or below than 3 years. If that is the thing, then under section 389, that particular court which has tried the accused, that is maybe Magistrate Court, maybe Sessions Court, it suspends the sentence till the appeal period is over. Why for? Because to enable that particular accused to approach the superior court by filing an appeal. But then it doesn't happen in cases where the applicant accused is awarded punishment or he is to undergo that punishment sentence which is more than 3 years. So therefore, friends, these are the various things which are to be taken care of. 438, 439, I have said. Then you will also find that this in newspapers, you must be reading that this particular case, in that case, capital punishment is given. Take case of Nirbhaya. this capital death punishment was given. Then we have seen all that courtroom dramas, the courtroom battles. Then this late night or early morning hours apex court was required to sit and consider the pleas. Why this has happened? Because any death sentence which is awarded by the sessions court is never to be executed unless and until it is confirmed by the High Court. Now that you get in chapter, this from section 366 onwards. So therefore, if suppose, that is why it is in High Court, it is called as a confirmation case, because that judgment and order of the sessions court, that is to be confirmed by the High Court, and then only it can be executed. But at the same time, that judgment and order of awarding death punishment, it can be also appealed by the accused person separately. So therefore, confirmation case and this appeal are normally heard together. And then the High Court decides whether the sessions court has appreciated the evidence correctly, the legal scrutiny takes place, and then the judgment is either confirmed or reversed. It so happens, friend, that therefore the appeals are there, provisions of appeal is there, provisions of reference and revision are there in the Criminal Procedure Code, where you get 397 is something like a very such a provision which talks about calling for a record to exercise the powers of revision, and 401 it specifically talks about High Court's power of revision. So therefore, whenever any revision, because friends, you must understand that whenever there is a conviction, there is an appeal. Appeal is a statutory right, but then after appeal, there is no second appeal. What we get in civil matters. In civil matters, of course, there is a second appeal, but in criminal matters, there is no second appeal. After appeal, there is a revision which is provided, and that revision is under section 397. If it is in High Court, it is section 397 read with section 401 of the Code of Criminal Procedure, where the High Court has a power to call for the records to see whether both the courts have appreciated the evidence correctly. You will also remember one thing, that appellate court, the first appellate court, rather the appeal where it takes place, maybe if suppose JMFC's conviction, sessions court. If it is sessions court, first the criminal appeal is before the High Court, because normally when from High Court things go in the apex court, these are called special leave petitions, criminal. And then, so therefore, whenever the appeal is there, appeal has to be considered, it's always called as the final court of facts, where the court will be looking into the evidence. Court will see. Of course, friends, fact remains that whatever evidence is recorded at that particular basic level before the court of first instance, which is trying the accused person, that evidence is intact. It cannot be said, there is no situation like this that you can add to it or you can subtract it. Of course, there are occasions when the accused person, they say that, sir, no, this particular evidence was not available to me, and therefore please permit me to place it on record. That those things also are there. But then Criminal Procedure Code takes care of each and every situation. I must tell you one thing, that a person, if suppose he is cremated, still that particular body can be taken out under the orders of the court, but while exercising powers under Criminal Procedure Code, because to see what was the cause of death. Because normally any natural death will not face any this thing. Unnatural death means, yes, there is something wrong. The person's cause of death has to be seen. Therefore, there are postmortems. Therefore, the postmortem, what is the cause of death? You must also see the postmortem notes. Normally, every time, whenever you are reading any postmortem note, please go to column number 17, where you will find all sort of injuries on that person. Now, those injuries, whether they are vital, they are crucial on the crucial parts of the body. What exactly? Because postmortem means practically you get everything from the body, and that gives you, ultimately leads to the cause of death, which is very vital in a criminal case. And that cause of death gives the court, the accused person, the prosecution, because cause of death means something has gone wrong somewhere. The person has not died naturally. Unnatural death. You will also find that there is a section in the Criminal Procedure Code, that is 174. It is in relation to accidental death reporting. Any death which is not natural is normally first reported as an accidental death. The accidental death case is registered. that is also investigated. Statements are recorded. But during the course, if there is a complaint by somebody that is near and dear to the victim or to some person who is no more or who is deceased, then that complaint comes, crime is registered. Then in that case, that AD inquiry, that all those papers are made available in that particular investigation. So it takes care of every possible situation. Therefore, friends, we have to see that this particular, then there is a provision regarding the transfer of criminal cases. You must have read in the newspapers many a times. There are so many cases where the cases are transferred from this state to other state, from this district to other district. Now, this thing can take place if suppose there is a sessions court division. And in that sessions court, some cases be transferred from one judicial magistrate first class to another judicial magistrate first class. The sessions court will has a power to transfer this thing. But if suppose a case is to be transferred from one sessions court to another sessions court, then it will not be possible for the concerned sessions court. It will be by the High Court. The High Court will be considering the request of either of the parties. If suppose a case is to be transferred from the territorial jurisdiction of one High Court, that is one state, to other state, then in that case, the Supreme Court will be considering that particular request or prayer. So this criminal procedure code, it takes care of so many things. Then you will also find that what is this imprisonment part? Imprisonment is something like, the death sentence, as I have said, it's the capital punishment. Then there is rigorous imprisonment, that is hard work is given. Then there is a simple imprisonment, there is fine. So these are the types of different punishment. Then you will also find, friends, that how the bails and these things, there are documentary formalities which are to be considered, which are to be taken into consideration. If suppose the court grants you bail, but it's a bail means that is a judicial order. Now, once that order is always subject to certain conditions, that this particular applicant is to be released on executing a PR bond, a surety. So these documentary formalities are to take place with the registry of that particular court. Then it will be also seen by the concerned court, normally by the court of first instance. Because in High Court, we will find in High Court, Supreme Court, whenever bail order is granted, bails order are issued, those orders normally they go back to the court of first instance, and there the documentation has to take place. There the courts have to verify everything, and then the release order goes from that court to the concerned jail where that accused is lodged in. So therefore, friends, there are also provisions in the criminal procedure code regarding disposal of the property, regarding the irregular proceedings, and so many things. But then, friends, when we are talking about the Indian Penal Code, as I said you, this classification, please remember it, because that will give you the correct picture as to what exactly the offense crime is about. Because offenses committed or alleged to have been committed, that's the vital piece to be considered. Criminal courts trying a criminal case means something in relation to commission of offense under some offense which is in Indian Penal Code. Then criminal courts, of course, they do try certain other offenses which are under special act also. But at present, when I am telling you regarding criminal major acts or law of crime, that is Indian Penal Code. In this particular thing, nowadays you will find that because of the changing situation, the things have come to this, that even in the past, the Indian Penal Code, particularly this section 274, that is adulteration of drug. There is one more section 332, that is voluntarily causing hurt to deter a public servant from his duty. And there is another section, that is section 353, that is assault or criminal force to deter a public servant from discharging his duty. Now, all these three sections, friends, this 274, 332, and 353, they were available in the past. But considering the fact that the changing scenario, nowadays you will find, you must have seen, you must have read, that is in this pandemic situation also, the doctors who are the messengers of God, they are being assaulted, they are being attacked. Now they are performing their official duties. But then some cases, so therefore taking a lesson from this, there are amendments. You know, friends, that there are law commissions established. Law commission give their suggestions, they indicate in their report, they suggest to the central government. Central government takes into, there is a committee for considering all these recommendations by the law commission. Then ultimately the law is legislated. You will find the law is legislated, these amendments are carried out, law is legislated in central, by the central government, by the state government. I must give you an example that 438, when we are talking about pre-arrest protection, anticipatory bail, but by state amendment in the state of Uttar Pradesh, that section 438 effect was taken away, because there was only this thing post-arrest bail, not pre-arrest protection. So therefore, the state government also takes care of certain amendments according to the needs, according to the problems, according to the situation, according to the things which are happening in that particular state. But central government has to consider the whole state, that is the whole country, a nation. And therefore, friends, this thing, these three sections, and particularly I must harp upon this, that 332 voluntarily causing her to deter a public servant from his duty, and 353, that is then this assault of or criminal force. These are now non-bailable offense. So friend, this IPC also, it talks about so many things, heinous offenses. There are persons who have criminal antecedents, that they are booked in an offense, they are tried, convicted. Suppose take a case that 302, here it has been proved that he has murdered somebody, he is undergoing life imprisonment, he is a life convict, and still he commits an offense. Maybe during the time that he comes on parole, maybe during the time that he is on bail. Then, so person convict or a person who is undergoing sentence, if he commits another offense of similar nature, then it is angled, then it is seen with a very distinct, that therefore section 303, that life convict committing a murder again, then it is viewed very serious. And therefore, friends, all these things, in there also in Indian Penal Code, as I said, in general explanations, chapter 2, you will get all definitions, what exactly is there. Then there are chapters in relation to punishments, then the general exceptions are there, then there are various things, conspiracy part, criminal conspiracy. You know, friends, conspiracy is being alleged nowadays time and again. But then conspiracy, that is section 120B of the Indian Penal Code. What do you mean by conspiracy? How it has to be proved? Conspiracy is something that it is very easy to allege, but difficult to prove. Because conspiracy means meeting of the minds. Meeting of minds of more than one person. Two persons are minimum. Their minds are meeting. They are deciding of certain strategy. And then their conduct has to be seen. What plan they have hashed out. That has to be proved before the court. Then only you can say that, yes, they have hashed a conspiracy. But then there are ways and means to prove those things by conduct, of course. Even if suppose there is no document, nothing is there in writing, still this can be done. And friends, so therefore this Indian Penal Code, then in this Evidence Act, it talks about, as I said, it talks about the admissibility of the evidence. So therefore, I have tried myself, of course, to the best of my abilities, that all these are three different things, codes and this thing. But then I have tried to give you a slightest idea, maybe a tip of the iceberg regarding all these three things. I hope that the new entrants like you must be quite eager to enter into this fascinating area of legal fraternity. And I wish you all the luck and wish you all the best. Thank you.
Thank you so much, sir, for such an elaborate session. Now we will move towards our question answer round. The
Yes.
first question we have is, if someone killed other person in self-defense, so can it will be treated as murder or not?
See, the defense, self-defense, if suppose he is taking a defense of self-defense, that he is being assaulted, then it cannot be said to be a murder. He is defending himself. So then there is no case of murder. But then self-defense cannot be excessive. If you are having a gun and a person rushing to you is having a stick in his hand, you are apprehending something to get assaulted, but that person is having a stick and you are having a gun, and in self-defense you shoot him, that is excess of self-defense, then that is a murder, though it seems in self-defense. But then self-defense means you want to protect yourself, then of course it is there. Yes, please, next question.
Thank you so much, sir. The next question we have is difference between substantive law and procedural law.
See, substantive law and procedural law, that's why I said you, criminal procedure code, when we talk about, it talks about the procedural part. Procedural part means how the courts are being regulated. The procedure in criminal proceedings in criminal courts of law. All things are regulated. Fortunately for us, it is codified in criminal procedure code. Substantive means this thing, that if you are convicted, you have a right to appeal, but then there must be some provision of appeal. There must be, unless and until there is provision of appeal, you can't file an appeal. But normally you find that even if suppose you are convicted or acquitted, whoever is at the receiving end, he has a right to file an appeal, maybe against acquittal, maybe against conviction, but then procedure part is concerned, it is criminal procedure. Yes.
Thank you, sir. The last question we have is, what is the difference between criminal intention and motive?
Yes, see, the criminal intention and motive means it is something like this. It may sound to be common, but then criminal intention means every offense when it takes place, of course, it is with guilty mind. The mind is guilty and therefore he is committing some act and therefore he is said to have committed some offense. That guilty mind, that intention, criminal intention. Motive means motive. In criminal cases, motive part is this, that if suppose I have done a particular act with motive means something like this, that that act has taken place because I wanted to do it to happen that way only. Suppose, I will illustrate, I will give an example of this. I am not well with my friend, and if suppose that friend and I have some political rivalry, maybe something like that, and if suppose I want to take revenge and then I do that particular act of killing, then in that case this motive part, because if suppose I'm committing some act, then motive means there is a plan, I must do it. But criminal intention means, as I told to you, this intention part is that guilty mind. This guilty mind has to be there. If suppose, as you said, your first question was in relation to self-defense. Self-defense is the best defense, but then it should never be in excess. That is what the law says. So therefore, criminal intention and motive also, they are in different fields. Yes, please.
Sir, one question from is that,
Hello.
if there is no registration of
Yes.
offense
Yes.
or FIR, but as far as section 438, there is an apprehension of arrest or reason to believe that he may be arrested,
Yes.
can he go for anticipatory?
Yes, I'll tell you, the academically, yes, you can. Means academically, but practically, no. The courts are always insisting upon the formal registration of crime. Actually, 438 talks about apprehension of mind in relation to arrest, in relation to some crime which is registered. But it so happens sometimes that you get an idea that you are going to be involved, implicated, framed in some crime. You are cocksure about it, but then still, and then you don't want to get arrested. You can go to the courts of law. It so happens many times that court considers your plea and court, but then that time police comes with the case. Police says that, sir, there is no formal registration of crime. Apprehension is rather premature. Then in that case, many times you will find courts are passing order that, see, mister, if at all, then as per his apprehension, some crime is registered, please give him notice. Maybe 24 hours, maybe 48 hours, maybe 72 hours. But then he has a right to protect himself. He has a, otherwise it should not happen that crime is registered and because he is booked, he is immediately arrested. So therefore, formal registration of crime is seen by the court, but even if it is not there, still you can go for anticipatory.
Thank you so much, sir, for your elaborative answers to the questions which were asked by our attendees. Now may I request may I request Amol Chauhan sir to have a concluding remark on this session.
Thank you, Rajeshri. Respected Senior Advocate Rajendra Deshmukh sir and all the attendees on this webinar. Sir, it is very excellent experience to listen the sir on the law of crime and the Code of Criminal Procedure and Evidence Act. Sir make a blend of this particular three laws and apprise us in a very lucid and in very simple language to understand the criminal law and its provisions. Now, I am here to cover the theoretical part of the law of crime because most of the part is covered by the Advocate Deshmukh sir. I am not going in detail of this particular provisions of law of crimes, where I put some the theoretical part where the IPC was drafted by the First Law Commission, which was established in the 1833. And the Lord Macaulay was a father of this particular law, and this law was introduced in India in the year of 1860. The whole provisions of criminal law is based upon, and it denotes the unlawful activities of the person which is punishable by the state. It means that unless the activity is prohibited by the criminal law, the person is not responsible for any crime, or the person is not responsible for as per the Indian Penal Code. It means that when the person commits the prohibited act or the unlawful activity, then that act may come under the purview of Indian Penal Code. Now, this body of laws, that is Indian Penal Code, is having the 511 sections and some amendments introduced by the legislatures. This body of law which deals with the imposing the punishment on the crimes is known as a criminal law. When we say that the Indian Penal Code is a criminal law, it means the Indian Penal Code is imposing the punishment on the persons who commit the crime. And for that reason, it is a substantive law. Substantive law means law where the offense is defined and some punishment is provided by the legislature. Now, the objective of this criminal law is to make a retribution in the minds of the person, that is called as a tit for tat. When the person is punished by the state, when the person is punished by the court, then it automatically it may create the retribution in the minds of the peoples. It may create the deterrence in the mind of the peoples. And now after 2013 and onwards, before also, the main aim of the Indian Penal Code was to create the deterrence as well as to retribution. But with the passage of time, this particular Indian Penal Code, which is providing the punishment in the form of rehabilitations and the restorations of the person. That rehabilitation means what? Only punishing the person is not the aim of that particular criminal law, but there is need to make the rehabilitation in the particular person for the better society. Now, coming forward, what are the elements of the crime? Basically, there are four elements of the crime. First is the actus reus, that is act or omission. Act, that is the act which is committed by the persons with an guilty intentions to commit or to cause harm or injury to the other person. Then that act may be that act is within the definition or within the purview of criminal law. Second element is that is called as a mens rea. Mens rea means a guilty mind. Unless and until you commit that particular act with some guilty intention, the person is not responsible as per the criminal law. As rightly observed by the Deshmukh sir and answered to your query about the self-defense. If it means, if suppose the persons who commits the activity under the purview of self-defense, then there is a absence of mens rea and the persons may be exempted from the criminal liability. At the same time, if suppose the person has a mens rea, then the particular court has right to punish the person. And next element is that is a human being. It means that the offense should be committed by human being on human being. If suppose the offense is committed on the animals, then that particular person is not responsible as per the Indian Penal Code. There are other laws where the person is liable for causing the harm or causing injury to the animals. It means that the persons who going to commit the offense and against whom the offense is committed, both person must be a human being. Unless and until both parties are human beings, the Indian Penal Code will not take the cognizance. Third and last element is that is called as an injury. Injury is defined under section 44 of Indian Penal Code. Injury means any harm which is to the person's body, mind, and reputations of the person. It means that by the wrongful activity, suppose the person commits any kind of injury to the mind, body, reputation, or property, then that particular person may be responsible as per the Indian Penal Code. These particular elements we may compose in the particular magazine, that is actus non facie reum nisi rea. It means that the only act is does not constitute the offense unless it is committed with the guilty intention. It means the main thing in the commission of crime is an intention. Unless and until there is a bad intention on the part of the person is not liable as per Indian Penal Code. Now, there are the four stages of crimes. First is a intention. That intention, that if suppose I have the intention to cause harm or any kind of injury to the person, it means I have the bad intention to cause the person. That is the first stage to commit the crime is called as an intention. Unless and until you think in your mind to cause harm, offense will not be committed. Now, taking your considering your intention when you make some preparation. Suppose, for example, I want to commit a murder. It means that the committing the murder or killing anybody or somebody, this particular thought should be came into my mind. Unless and until that particular thought is came into my mind, I am not responsible for any offenses. For satisfying my intention, when I prepare something, if suppose I purchase the knife from the market and I want to kill somebody by using the knife, it means purchasing the knife, possessing the knife, that is called as a preparation. But at the same time, when I purchase the knife from the market, I may be a different intention. I have maybe an intention to use that particular instrument in my home for cooking or other purposes. It means that unless and until that preparation shows in the form of attempt, the particular person is not responsible for the now. The last is that is called as an accomplishment. Accomplishment, that is called as a completion of the offense. If suppose I have the intention, I make a preparation as per for satisfying my intention, and for preparation I suppose I try to commit the offense. Then if suppose the offense is committed by me, then only the particular person is responsible as per the Indian Penal Code. See, there are four steps, that is intention, preparation, attempt, and accomplishment. For the particular these two stages, that is intention or preparation, nobody is responsible, because unless and until that intention and preparation reflect through your activity, the person is not responsible as per the Indian Penal Code. Now, so the Indian Penal Code is considered a series of chapters, and there are a series of sections which is defined and which is deals with the different kind of offenses. That is offense against human body, which it is already discussed and covered by the lecture. That is section 299 to 377, offense against property, offense against state, offense against woman, offense related weight and measurement, and there are new categories of offenses which is inserted by the new criminal law amendment act. Apart from that, there is a provision or there is a separate chapter relating to the general exceptions. That is general exception, that is called as a right of private defense. When the person is not responsible for the offense, so the offense is committed by the person. This particular part is also professor. Now, the most important sections of the Indian Penal, that is no doubt that all sections are important, but section 34 and section 149, section 107, section 20A. That is section 34 says when two or more persons common intention to commit the offense, that every person is equally responsible. Whereas section 149 speak about the common object. When five or more persons committing the offense with a common object, then the particular peoples were equally responsible in the eye of law. So far section 107 is concerned, section 107 is speak about the abatement. That is abatement before fact, abatement during fact, and abatement after fact. Now the criminal conspiracy, when two or more persons committing the offense or plan something to commit an offense, which is covered under section 120A. Now the most fascinating part, that is called punishment, which is defined under section 53. This particular topic is also covered by this, sir, where the from death sentence to the fine, that is death sentence, imprisonment for life, rigorous imprisonment, simple imprisonment, and the fine. These particular kinds of punishment is provided under the Indian Penal Code. With this, I conclude that the Indian Penal Code is a very fascinating subject which covered the various offences and various criminal and illegal activities by the persons. Thank you very much. Over to Rajeshri.
Thank you so much, sir, for inviting me. Now, it's my privilege to have been asked to give a vote of thanks. Rajeshri Saure, LLB second year student, giving vote of thanks. Firstly, I would like to thank to Senior Advocate Rajendra Deshmukh sir for a very elaborate discussion on law of crimes. I further like to thank our principal in charge and my of law college in to thank sir and Amol Chavan sir for organization of this webinar. And there is one notice to all our attendees that on tomorrow, that is on 23rd July, we have with us Professor Kolte sir for the topic on general principle of Indian Contract Act at 12 p.m. to 1 p.m. I request the attendees to attend this tomorrow's webinar as well. Thank you. Stay home, stay safe.
Thank you, sir. We are going to
Thank you.
stop webinar. Thank you.
Okay. Stop video.